This is sections 8 and 9 of the residential real estate purchase contract. Section 8 is additional terms and conditions, and it starts on page 8 of the contract, actually, with one big, huge blank page. This is where other things can be written into the contract that the buyer has decided they wanted to add on to the contract. If you have stuff along the lines of furniture is a big one in here. We'd really like to have the big couch. You would write that in there. Also, anything else that you just want to highlight out. In a lot of cases, you'll see if the seller is a licensed real estate agent, or if the buyer's a licensed real estate agent, they need to. This is the lines where they put that in to notify the other side that they are dealing with a licensed real estate agent, which is a big thing here in Arizona. This is also where a lot of real estate agents get themselves in trouble because they think they're attorneys and they start writing stuff into the contract as if they are an attorney. And their concept of what they wrote down might not actually be the same concept of what the seller and seller's agents reads on the other side, which is why we really like to use boilerplate stuff. There is a separate addendum you can add on to the contract that has a bunch of the pretty standard stuff that you see quite often, like waiving the appraisal period or the inspection period, waiving the appraisal. Various things along the buyer's contingency is actually a completely different form. But this is the line where you can write other things in and use this at your peril. So going into the rest of Section 8, we have a whole bunch of terms that it's almost like the glossary of the contract, and we're going to highlight a couple things so everybody is using the same definition of the words. So first paragraph here, 8B, and this is also the last part of the last punch out in the contract for either the buyer or the seller, is that if the property is damaged because of fire, vandalism, flood, earthquake, or act of God, the risk of loss shall be on the seller. Meaning the seller has to assume the damage unto themselves. The buyers doesn't have any damage, any of the damage going to them. All right. Provided, however, that the cost of repairing such loss or damage would exceed 10% of the purchase price, either seller or buyer may elect to cancel the contract. Now, if you remember, a couple sections back, the contract was saying that the seller was going to maintain the property in the condition it was when we went under contract. So if let's say a tree falls on the house, smashes the roof, the seller by the contract is actually obligated to get the roof repaired before close of escrow. Because of the risk of loss in that 10% line, if the cost of the damage exceeded 10% of the purchase contract, meaning $300,000 house, cost of damages and everything is over $30,000, right, the seller may pull out of the contract at that point, or the buyer can walk away with the contract. So that's your final punch out right there. And that question actually comes up a lot more often than you might think. Especially the buyers, like, okay, what happens now? We've appraised, we inspected. We're in that final stage of contract where we're beating the lender like a piñata until money comes out, and they start going, what happens if the house burns down? Well, you don't have to buy the house at that point. So that's covered under risk of loss. 8C is a little CYA for the real estate agents. The buyer and the sellers are granting the brokers permission to advise the public of this contract. That gives us the legal authority to change it from active to pending in the MLS. 8D in here, Arizona law. The contract is governed by Arizona law, and the jurisdiction is exclusively conferred into the state of Arizona. That is to make sure that a citizen of an outside state, let's say California, because I like beating up on them, a California citizen cannot sue in a California court to enforce a Arizona contract and Arizona property. And that's boilerplate that our attorneys put into this contract to make sure we don't have people basically shopping through the different courts and whatnot, trying to find a very, hey, Delaware laws, they'll let you sue anybody, so let's sue them in Delaware. So yeah, Arizona law, Arizona land, Arizona courts. All right, another line in here, time is of the essence. This is under 8E. This one right here, this is a legal term. All right, and it doesn't sound like a legal term, but it is a legal term, all right? It's that the parties are acknowledging that time is of the essence and the performance of the obligations described therein. So by signing the contract, you're acknowledging that time is of the essence, and that means that you can be held responsible if you decide not to do what you were supposed to do contractually. All right, so that's a little stick right there in the contract. 8F, this is compensation. And this is another CYA for the real estate agents and a clarification for many, is that the seller and the buyer is acknowledging that the brokers, both real estate agents and their brokerages, shall be compensated for services rendered as previously agreed by a separate written agreement, which shall be delivered by the brokers to the escrow company for payment at close of escrow. Right? If not previously paid, if seller is obligated, if not previously paid, right? If seller is obligated to pay brokers, this contract shall constitute an irrevocable assignment of seller's proceeds at close of escrow. If buyer is obligated to pay brokers, payment shall be collected from the buyer as a condition of close of escrows. All right. So that's basically how Ray gets paid. Now, if you're working with a buyer and the buyer's agreed to secure your commission, let's say we've done a buyer-broker agreement. We're going to be doing that in a later episode. A buyer-broker agreement saying that for me going around with you and looking at all these houses for the next 4 months, you're going to guarantee me that I'm going to get a 3% commission off the sale of the house. All right, that's an agreement between the buyer's agent and the buyer themselves. The buyer is guaranteeing that the buyer's agent is going to receive 3%. So the seller has gotten into agreement through the listing agreement that the seller is going to compensate the seller, and in most cases, the buyer's agent, a certain percentage of the sales price, or it can be a flat fee. It can be a fixed amount. Regardless, this paragraph in here is both the buyer and the seller agreeing that the agents and the brokers will be paid out of close of escrow. And there's one other thing in here, and this is where it's not in bold, but it is capitalized. So think of this as not yelling, but a strongly stated. Commissions payable for the sale, leasing, or management of property are not set by any board or association of realtors or multiple listing service or in any manner other than between the broker and the client. That is the first negotiation. There's a lot of in the public and out there is that we have a set fixed commission fee for everything. That is incorrect. That is not true. That has not been legal since the Sherman Antitrust Act was passed way back when. Individual groups performing a service cannot get together and collude against the public to fix rates. Right? And the reason why we put that in there, and the reason why that's in this bold, is because we still have people think that. And in fact, I do believe the Department of Justice is currently investigating not the Department of Real Estate, but the National Association of Realtors to see if they are actually doing this. All right. I don't think that one's going anywhere. But that is, here called out. The seller is going to talk to a listing agent, and the listing agent and the seller are going to negotiate a commission for the seller's agent to sell that place. And if, the buyers come across a buyer's agent who's requiring a guarantee of commission, that is also going to be individually negotiated out. And sometimes we don't, as agents, we don't know what the other side's getting until we actually see the final settlement statement, and we realize, oh wow, yeah, they're taking 4% and only giving 2% out. So that's just calling it out. That's the purpose for that entire paragraph right there. 8G is copies and counterparts. Because we live in a digital age and we're constantly shooting papers back and forth, and this isn't, the way it was back in the founding of the state, where you would get on your horse with a copy of the contract, ride out to the ranch, get somebody to sign it, and then ride back into town and find the buyer or the seller and get them to sign it. We can actually have two separate copies of the same document. The seller can sign one and the buyer can sign one. And those two pieces of paper put together become one contract. So that is called a counterpart or a countersigned, right? There can, you countersign on two different documents, it becomes counterparts to each other. So the only document we can't do that thing is the lead-based paint disclosure. That has to be signed all on the same piece of paper, not at the same time. And you can still, pass a copy back and forth, but you can't do the two different pieces of paper with 2 different signatures on each one. You need to have one document with everybody's signature on it at the end of the day. All right, days. This is something else we call it because it creates confusion. If you are looking at a digital clock and the number on there is 12, it's the next day. If it is 11:59, it's, well, still the day that you're looking at it, but it's considered the previous day. The day is considered magically going from Saturday to Sunday, Sunday to Monday, Monday to Tuesday, when you're suddenly seeing the 12 flash up there. All right, so days start at 12 a.m. and they end at 11:59 p.m. And the reason why we call that in the days is because the next one, when we're calculating time periods, and you remember in this contract we've had a whole bunch of triggering events that kick off a time period. The inspection period starts right after, you know, the contract is signed and confirmed. All right, and then the inspection period starts the next day. All right, so, and then you have so many days to do it. Let's see, we got that. For some reason, the concept is completely escaping me. You got your cure notices, you know, where there's a 3-day period going on that. So when you think of the triggering event, then the days start the next day. So if you have a 3-day period, all right, I'm going to go at this route. Let's say it's Monday. All right, Monday the triggering event happens. Monday the final signature is signed. The seller signs the contract, and it kicks off the period. All right, that was Sunday. All right, they could have signed it and it has not opened. The buyer's agent has not opened up the email, but they've signed it and they've sent it on Sunday. That means Monday is the start of the inspection period. All right, Monday, Tuesday, Wednesday, Thursday, and so on forth until 11:59 of the 10th day. So, calculating time periods. The reason why we had to call this out is because people does it start at the same time? No, it starts when any triggering event happens. The time period for that triggering event starts the next day when the numbers turn to 12. Now, if something comes up because of all this thing where let's say we have close of escrow, something happens and let's say the recording office is closed, bank holiday or something, you're right, it goes to the next day, but that does not include an inspection period, just if it's very specific, the recording office and banks are closed. All right? The other thing you got to remember on this is that there's acts that need to be performed 3 days prior to something, like 3 days prior to the close of escrow, needs to have 3 full days prior. So they use an example here. If the close of escrow date is Friday, the acts that have to happen need to be performed by 11:59 on Monday. Everybody misses that one, especially lenders. The entire agreement, this is 8J. This is the entire agreement, this contract right here. We can add addendums to it. We can add attachments to it, right? But nothing that has been written before or any oral agreements between the buyer seller, are included in this agreement, right? And now 8K, subsequent offers, the seller has the right to continue shopping the house, continue to try to get other offers to come in, but they have to honor their accepted offer. And even if they have a backup offer that's for more than the existing offer, they have to honor the existing contract and do everything possible to close on the existing contract. All right. Now, cancellation happens because whatever reason, inspection period, failure to get the loan. All right. A party who's wishing to exercise a right of cancellation cancels the contract by delivering a notice stating that they're canceling the contract to either the other party or they can send it to the escrow company. All right. That is considered effectively immediately, as soon as it is delivered, not received. All right. Addendum is under notices unless otherwise provided. Delivery all notices and documentation required or permitted hereunder shall be in writing and deemed delivered or received when it's hand delivered, it's sent by a fax, it's sent by email, and if email addresses are provided in, or sent by a recognized overnight courier service and addressed to the buyers in the addresses before. So it is considered not just delivered. Remember that. All right. Line 425. All right. It's going to be in writing, and it's going to be delivered and received when that happens. You do not need to provide a signature line from the courier company stating that the other side got the package or anything like that. And this is, I've seen this screw people up before. It's like literally you send them notarized or certified mail. They get the notice that they need to go pick up certified mail, and then they duck it for 5 days. It gets sent back to the sender. Recipient did not pick up. You can literally take that to court. And when the other side says, oh, I never received that you put the piece of paper down in front of them, unopened letter stating they tried to deliver this for 5 days, and the courts will all day long saying, hey, you as the recipient had the responsibility to go down there and see why you had certified mail. That happens a lot in rentals when it comes to evictions. People decide, oh, if I never get the notice, I never actually have to admit that I know I'm getting evicted. So, that's how notices happen in these things. Paragraph 8N. This is, it's also in bold, and this is another CYA for the agents. And release of brokers. Sellers and buyers hereby expressly release, hold harmless, and indemnify brokers in this transaction from any and all liability and responsibility regarding financing, the conditions, square footage, lot lines, boundaries, value, rent rolls, environmental problems, sanitation systems, roof, wood infestation, building codes, governmental regulations, insurance price in terms of sale, return on investment, or any other matter relating to the value or condition of the premises. The parties understand and agree that brokers do not provide advice on property as an investment and are not qualified to provide financial, legal, or tax advice regarding this real estate transaction. And we have the sellers and the buyers separately initially understand that they understand it's not Ray's fault. All right. So next paragraph on this thing, 8O, is the terms of acceptance. Now, this offer gets sent over to the seller, and the buyer puts in a date and time, and they're saying this offer is good for us till Sunday at 6 o'clock. All right. We saw the house on Saturday morning. We liked it. We wrote an offer. We're only going to give you till Sunday night to get back to us on this. All right. At that point, it is no longer binding on the buyer. All right. This is only an offer that is capable of being accepted by the seller within the time frames given in the contract, and this is where we put the time frames in there. Now, in reality, if a buyer does not have by 7 o'clock on Sunday afternoon or Sunday evening a accepted contract, but instead the seller's agent calls the buyer's agent up Monday morning at 9 o'clock going, hey, my guys just got into town and saw your offer. Is your buyer still interested? 99 times out of 100, the buyer is still going to be interested. But this just means that the buyer is not going to be held accountable and, to the contract if the seller goes past that time point. Right? So that's a line in here that says offer shall be deemed withdrawn and buyer's earnest money shall be returned. And that's just in there for in case, like in the old days, the brokerage actually had their own trust account. The seller's agent would have been holding on to a check that entire period, and they would have deposited those funds in the seller's trust account. This would allow, or the buyer's agent trust account, this would allow the trust account to turn the money back over to the buyer. Right. And then 8P, this contract contains 10 pages exclusive of any addendum and attachments. Make sure that you have received and read all 10. All right. And of this offer as well in any addendum or attachments. Just calling it out to make sure everyone remembers there are 10 pages involved. All right. Do you have all 10 pages? Way back here in the first page, was there a call out that there was extra addendums coming in, like HOA lead-based paint? All right. So if you're looking at this and you go, I'm counting 10 pages and I don't see an HOA and lead-based paint disclosure, you're missing parts. All right. So that wraps up the end of that page. And then the last part is where the broker puts their information in of who they're working for. All right. Charles Dawson, agent MLS code, CD509, state license number, address of the brokerage you work at. And then right here on 8R, this is the only document, this is the only line, it's 2 lines, where there's an actual affirmative declarative statement, right, that the buyer's agent is actually the agent of the buyer. Or the seller. Or both the buyer and the seller. And this is important because, you don't need to have, don't tell the Department of Real Estate I told you this, and definitely don't tell the Board of Realtors I told you this, you don't really need a licensed sales agent to sell your house. All right. If someone's working for you at that, they're working for you as your agent. This is where you actually check and say, yeah, Ray's my agent. Or Ray's both of ours agents, something called dual agency. All right. That's the one line where it's actually called out. And then, and only then, does the seller sign or the buyer sign. They're going to print their name out. They're going to put their address, city, state, and zip code. Just remember back here, if we have stuff to send to people, we need to have their address. We're also going to make sure that they put the month, date, and year, and they're going to initial that. That's the offer. Once we've hit this point, we've got a completed offer, and we send it over to the other side. Seller. Now, this part 9 here really needs to be filled out by the seller's agent. But if you were a nice person as the buyer's agent, you have most of this information available. So you're going to fill out their name for them. You're going to get it off the MLS. You're going to put in their code. You're going to put in their state license number and really help a fella out and put this extra information in. All right? And then the first thing happens on this side is the seller is going to confirm whether or not the person listed up here is their agent or both the buyer's and the seller's agent. And then there's right here, the undersigned agreed to sell the premises on the terms and conditions herein stated, acknowledge the receipt of a copy thereof, and grant permissions to broker named in Section 9A to deliver a copy to the buyer. Seller signs, puts all their information in, and we have an actual contract. Or you can click this little box right here and says, we agree to just about everything, but we got a counteroffer. And a counteroffer is a completely separate form. And this is where the seller gets to come back going, I don't like your price. Can we bump it up? I don't like your terms, your inspection. Can we change that? No, I'm not letting you have the couch. Whatever comes in the counteroffer comes in on the counteroffer. So then if those terms are acceptable to the buyer, then the buyer will sign the counteroffer, and then we have an accepted contract. So when the seller sends that counteroffer over, that's a one-shot deal. It's a one-shot negotiation. It's like you come in and say, you offered me $300 and I want $310. I'm sending you over a counteroffer for $310. If the buyer signs that, you're under contract, and so you get one shot to send out that counteroffer. And that doesn't mean that you can't go back and forth 5 or 6 times. It happens, but still, the counteroffer goes back and forth until we have an accepted offer by both parties, and then this contract and any additional counteroffers that might have gone back and forth as we hash things out all get added together and become the contract. So last line on here, and this is just sort of an inside baseball, is that if the offer is rejected by the seller, right here, the seller needs to be presented with every offer that they get. Every offer that they get needs to be signed, or not necessarily signed, but at least initialed by the seller, that the seller actually got this. All right? This is a requirement. I get maybe 1 out of 10. Out of the 10 offers we get out there, I might get one of these things actually checked, rejected by seller, so I can tell my buyers without any misgivings, yes, the seller saw your offer. All right. Now, if you're asking yourself, if I'm listing a place, how many buyers agents get their offers rejected and the document back? All of them. All right. I don't have the seller go through and initial every page of every contract. I'm just sending them back this page right here with a rejected month, date, year. Have the seller initial it. All right. And you can put 5 and 10 of these things in front of people, and they can just do their initials 10 times. And then you just need to make sure you're getting the right one out to the right person at that point. All right. But this is a requirement. We're supposed to do it. Do people do it? No, they don't. It's really simple. Knock it out. This will both save the seller a lot of heartache, the buyers a lot of heartache, and sure as hell all the real estate agents involved in the transaction if they're getting these documents over to them. Last thing in here is, because once we have a contract, we have to let the brokerage know. Broker is then sitting there going to file and log it in our big ledger. So in case the brokerage ever gets an audit, we can pull that out. All right. The manager, if there is one, is going to initial it, and the broker is going to initial it and date it, and that's when it becomes officially logged into the brokerage's books. So this is the last part of the contract. And this finishes out the residential real estate purchase contract.